All right. For our last speaker, we have Colin Calhoun. Mr. Calhoun, as I said before, is an attorney in private practice. He regularly represents individuals who are from Iran. Many of them have various levels of English proficiency. He's had extensive experience using interpreters in court and also extensive experience dealing with the nationalities issues as well as just the language issues in representing these parties. I'd appreciate it if you would share a bit of your background, how you came to represent these individuals, and what kind of challenges are posed when you have a non-native English speaker, a non-proficient English speaker, and getting what they consider to be fair consideration of their case.
Thank you, Matt. First and foremost, it's a great honor to have the opportunity to share my experience representing limited English proficient persons. Specifically, I'm going to talk about my experience representing LEP persons who speak Farsi. About 9 years ago, when I was still a student, I worked with a gentleman from Iran, and he immigrated to the United States almost 35 years ago after the Islamic Revolution in 1979. He's a member of the Baha'i faith. Members of the Baha'i faith are severely persecuted in Iran. The persecutions significantly intensified after the Islamic Revolution in 1979. At this time, as I understand, there are about 900 members of the Baha'i faith here in Middle Tennessee. As a result of my friendship with this gentleman, I had an opportunity to learn a lot about Persian culture, and in my practice, I've had an opportunity to provide representation to many individuals who speak solely Farsi. They're very limited in their ability to communicate in English at all. And there are 4 points that I want to touch on. The role of interpreters, my experience working with Farsi-speaking persons who have very limited ability to communicate in English, the concerns of those persons, and the effect of interpreters. The role of interpreters in our court system is vital because the essence of language is of critical importance in ensuring that those with limited English proficiency have access to justice. There is a difference between an interpreter and a translator. Interpretation pertains to oral communication. Translation pertains to written communication. Interpreters are governed by Tennessee Supreme Court Rules 41 and 42. In Tennessee, there are 3 different types of interpreters that are recognized: certified court interpreter, a registered court interpreter, and a non-credentialed interpreter. A certified interpreter will have passed an oral and a written test. A registered interpreter will have passed a written exam, and a non-credentialed interpreter will have not passed any test. There is no certification or registration. The fees for interpreters are governed by Tennessee Supreme Court Rule 42, Section 7H. A lot of the fees associated with interpreters are covered by the Administrative Office of the Courts, particularly in reference to court proceedings. The fees are much more expansive in criminal cases. In civil cases, it's much more limited. However, I do want to point out an important distinction. Tennessee Rule of Civil Procedure 54.04, Section 2, now provides that the expenses that are specifically excluded by Supreme Court Rule 42 are now discretionary expenses. Now, this is critical from the standpoint when I am preparing a Farsi-speaking client to participate in a deposition or for trial. I may have to spend a significant amount of time preparing my client for a deposition, working on discovery, working on pleadings, motions, and I may have to hire an interpreter to come to my office and help facilitate that. And under the discretionary cost rule, I now feel I have a viable basis to request taxation or ask the court to award discretionary costs for expenses of that nature. Oftentimes when I'm preparing a Farsi-speaking client for a deposition or a trial, it may not always be feasible for me to work with an interpreter, and sometimes I'll work with a family member, maybe a daughter, a son, a brother, someone who can speak effectively in English to get the job accomplished, to complete a verified complaint, to complete written discovery. And oftentimes I can avoid interpreter expenses in doing that. There are complications as a result of that because the family member or friend may do a sufficient job, but oftentimes they want to interject their personal feelings about the case and ask me why a whole bunch about why is this way, and it really slows the process down. But to me, it's worth it, and I do my best to be patient to get the job done. The main concern that I always see when I meet with a Farsi-speaking person for the very first time is you can see in their eyes the trepidation. They feel overwhelmed. They feel like it's an insurmountable endeavor to have access to justice and be on a level playing field with someone who speaks English in a courtroom. My primary objective from the very beginning when I meet with that person for the first time is to make sure that I can communicate with that person effectively in English and to do my best to instill trust and confidence in that person so they understand my role as the lawyer, they understand the role of the interpreter, and they understand the role of the court. And it's of critical importance throughout all stages of the proceeding that I coordinate with an interpreter so that the client is kept abreast and apprised of everything that's going on with the case.
So, Colin, let me ask you a question. Okay, you have a client who's Iranian, a member of the Baha'i faith, and there is an interpreter who is also born in Iran as well, and he's a Muslim. How does that affect the ability to interpret and the comfort level or the relationship between the interpreter and the client or the witness?
I think it can have a significant impact if it's known, because someone who is Baha'i is going to have a sense of distrust regarding someone who is Muslim. Someone who's Baha'i is going to be able to relate and have a sense of trust in someone who can speak their language, because the interpreter will be able to relate to their plight, their circumstances, how they came to immigrate to the United States from Iran. And that sense of trust is automatic in those circumstances. And if the interpreter is of a different faith, it's a little bit more difficult to instill that sense of trust and develop that.
All right. You've got parties who neither of them are proficient in English. Both of them need an interpreter. There is one certified interpreter, Iranian Farsi certified interpreter here in Tennessee. What happens?
That is correct.
Can that one person be the interpreter for the entire case?
That is a big concern. In the state of Tennessee, to my knowledge, there is only one registered Farsi interpreter, and he's excellent. I've worked with him quite a bit. He's superior. But if you have a Farsi-speaking plaintiff and a Farsi-speaking defendant, it is vital that you have two interpreters, because I'm going to want to communicate with my client during breaks. The interpreter is an officer of the court, is going to be bound by attorney-client privilege. I'm going to communicate with the interpreter directly with my client, and it's going to be difficult for the interpreter to do that effectively for both sides. It's also going to put the interpreter in an awkward position, having to do that for each side. It can be done, but it's not good to do that. And also, it's very important that when my client is sitting next to me and another witness is up there testifying in English, I want my client to know everything that's being said on that witness stand. And my client needs simultaneous interpretation at that time. Now, it's my understanding the ALC has made the equipment available to various courts so that endeavor can be accomplished. But that's something that's very important too. And if you only have one interpreter doing that for both sides, the effectiveness of that interpreter is going to be severely compromised.
If you could take 1 minute and wrap up.
Absolutely. I want to speak briefly about the unintended effects of interpreters. Interpreters are charged with providing a complete and accurate interpretation. They're not to interject their own personal words, thoughts. However, perfect interpretation is simply not possible, especially if you have a lengthy exchange regarding the source language being English and the target language being Farsi, input-output. It's just not going to happen. There are going to be certain phrases used that may not have the proper meaning that the witness is trying to convey and what the interpreter provides in the interpretation process. And the biggest concern in light of that, and I will say I never have worked with an interpreter in a jury trial, only bench trials, but a big concern is the jurors must understand the role of the interpreter, because you may have a juror or jurors who have familiarity with the target language. They may know some Farsi. They may know what some of the words mean, and they may ascribe a different meaning to the testimony that's coming out of the interpreter's mouth. So it's very important that that jurors are charged with an instruction when an interpreter uses that the jurors are to base the evidence that they consider solely on the official court interpreter. That way there is no confusion. You don't have to worry about the interpreter telling the other jurors, well, I think this is really what the witness meant. And I know that in the criminal pattern instructions in Rule 1 in Tennessee, there is some language in there pertaining to interpreters, but I don't believe there is regarding the civil pattern instructions. But it's very important that an instruction be charged to the jury under those circumstances.
Great. Well, as you see, there are multiple different perspectives from which this subject of access of justice needs to be considered. And today we've just had a sampling of each of those. And there's a lot more to do, a lot more to consider. And this is an invitation to all of us to become even further involved in this issue of furthering the initiative of the Supreme Court and to promote access to justice in its broadest sense. And if we can give a hand to our panelists.